Most people think that if you buy a bit of agricultural land and put in enough hard work, you'll eventually be allowed to live there. It sounds sensible, but that's exactly where people get caught out. The reality is that farming the land and living on it are two completely different things in planning law. In this video, I'll explain how small holdings sometimes become legitimate homes, why evidence matters more than intention, and why even living in a caravan in someone's garden isn't always as straightforward as people think. Living on the road, waterways are off-grid in the UK, Dickie Dread. And we're on part 30 in the video series, still on chapter 3, living on the land, water, parking up and planning reality. And this is the third in a number of case studies using the information we've covered in the chapter so far. So, case study, gradual agricultural establishment. A small holding rarely begins as a finished idea. It starts quietly, often with very little, a few animals, some planting, maybe a bit of structure in how the land is used. In planning terms, this early stage matters. What you're doing is establishing use, and use is what the system recognises. Land is simply owned is one thing. Land that is actively worked begins to fall into a different category. Under the Town and Country Planning Act 1990, most agricultural use does not require planning permission in itself. Grazing animals, growing crops, managing land, these are generally lawful activities, but living on that land is treated very differently. Residential use is a separate planning matter, and this is where the long game begins. Over time, what starts as low-level activity can develop into something more structured. Fencing goes in, water systems are set up, animals are bred rather than simply kept. Produce may be sold, even if only locally or informally at first. What you're building, whether consciously or not, is evidence, not just of activity, but of continuity, viability and intent. Planning authorities do not grant permission for on-site residence simply because someone wants to live there. The key test is functional need. This comes from policy rather than a single statute, more notably from the National Planning Policy Framework and its supporting guidance. The question is whether there is genuine agricultural rural business that requires a worker to live on the site for a proper functioning. This is where time becomes critical. A small holding that has existed for years, with records of income, expenditure, stock levels and outputs, is a very different position from a newly occupied field with a caravan on it. Councils and planning inspectors will look for evidence that the enterprise is not only real, but financially and functionally credible. That often includes basic accounts, stocking densities, land use plans and proof that the work cannot reasonably be managed without an existing dwelling nearby. There is also a stage approach in planning practice. In some cases, temporary permission may be granted first, often for a caravan or mobile home, to allow the enterprise to prove itself. This reflects long-standing guidance originating from documents such as Planning Policy Statement 7, Sustainable Development in Rural Areas, now absorbed into the National Planning Policy Framework. If the business demonstrates viability over that period, an application for permanent dwelling may follow. Alongside this, there is the separate regulatory layer under the Caravan Sites and Control of Development Act 1960. Even where a caravan is used, its stationing for residential purposes can constitute development unless it falls within specific exemptions or has planning permission. Again, the issue is not the object itself, but how it is being used. What emerges from all this is not a quick route, but a process. Activity leads to evidence. Evidence supports a case. The case is tested against planning policy. Only then does the question of residence become realistic. For those coming from off-grid or traveller backgrounds, this can feel a little at odds with lived practice. People are used to making do, adapting, building incrementally without formal approval. But the planning system does not work on intentional lifestyle. It works on demonstrable use and policy criteria. The more your activity aligns with recognised agricultural rural enterprise, the stronger your position becomes. Eventually, in some cases, permission is granted, but when it is rarely because of a single application or a clever argument. It is a result of sustained effort, consistent use and the accumulation of evidence over time. Even then, conditions are often attached, occupancy restrictions tied to the enterprise, limits on further development or requirements to maintain the business. The reality is that this route is possible, but it is not casual. It requires patience, documentation, and an understanding of how planning law interprets land use. What begins as a small holding can become a legitimate basis for living on the land, but only when it can be shown clearly and convincingly that the land itself justifies the presence. Living in a caravan on residential land. One of the most common questions is whether you can live in a caravan in someone's garden, a parent's place, a mate's land, or your own house. The answer is sometimes, but it depends how you use it. Planning law draws a line between something that is part of the main household and something that has become a separate dwelling. A caravan can usually be kept and used in a garden without planning permission if it is incidental to the house. That means it is clearly part of the same living arrangements rather than a standalone home. Where people get into trouble is when the caravan becomes self-contained. If someone is living entirely in it, cooking, washing and functioning as a separate household, councils may treat this as a material change of use. At that point, planning permission is normally required, and enforcement action can follow if it is not granted. You will often hear people say that you need to eat 1 meal a day in the house to make it legal. This is not a rule in law. It's a rough way of describing how planning officers assess whether the use is genuinely part of the main dwelling. What actually mattered is the overall pattern of living. If the caravan is clearly dependent on the house, it's more likely to be accepted. If it operates as a fully independent unit, it's more likely to be challenged. As with much of this chapter, the difference between what people do and what is formally allowed can be significant. Plenty of arrangements exist without issues for years, but if a complaint is made or the council takes an interest, it is the planning definition that will be applied. This gap between practice and enforcement is not consistent across the UK. Scotland and Northern Ireland often operate with different enforcement cultures, resources and priorities. In some areas, lower population density and rural contexts can result in slower or more selective enforcement, while in others, particularly around settled communities, action can be just as rapid as in England. So, what's the real lesson? Owning land or working land doesn't automatically create the right to live there. Planning decisions are built on evidence collected over time, not personal preference. If you're trying to live differently, this isn't just about buying a field or parking a caravan. It's about understanding how the planning system actually works before discovering it the hard way. In the next video, we'll look at a real case study that illustrates many of the planning system complexities. So we're on Chapter 3, Living on the Land, Water, Parking and Planning Reality, and we will cover the case study TP Valley.